So it looks like he's on bond for reckless driving in court 14. And that's what probably led him to him here.
That's correct, Judge.
What's he wanted for?
I'll let Amy go ahead and speak to
So
that.
they double confirmed with the main jurisdiction this morning for DUI causing death.
Judge,
And
actually,
he's driving like a maniac now. Can you bring him out, please? Morning, Mr. Mathis.
Morning.
How's jail?
Miserable.
Good. Makes me very happy.
The video opens with the judge reviewing the defendant's history, and instantly, things look bad. He's already on bond for reckless driving, and before we even settle in, the judge mentions a DWI causing death out of Mississippi. You can hear the disbelief in her voice, and when she brings him out, she asks, "How's jail?" His answer, "Miserable." The judge's reaction, "Good, makes me happy." A brutal start, and it sets the tone for everything that follows.
Looks like you're wanted out of another jurisdiction for a DWI causing death.
Yes, sir.
And now we have you here because you picked up a reckless driving. You want me to let you out?
To go to Mississippi. Yes, sir.
It's cute. I don't even know what happened. Let's figure out what happened in the reckless driving.
Judge, in the reckless driving, on August 25th, 2024, officers were patrolling the southbound of the 7600 blocks of East San Luis Tollway South. Officers observed the defendant in a black lifted truck traveling at a high rate of speed. The officers captured it speeding for radar at 97 miles per hour and 65 miles.
As the judge continues, we learn the defendant wants to be released so he can travel to Mississippi to face that deadly DWI case. But then the reckless driving report is revealed, minus 97 miles per hour in a 65 zone, weaving through lanes, cutting across traffic, forcing other drivers to brake. It paints a picture of someone who refuses to slow down, literally and figuratively. Do you think someone with a past like this should be trusted to drive again?
Hour zone at the 9200 block of San Luis Tollway. As officers attempted to catch up to the vehicle, the officer observed the defendant cut across different lanes of the highway while failing to signal and cause other vehicles to brake. Officer observed the vehicle following other vehicles closely as it cut up.
don't say anything specific, Judge. I would like to state that this case is out of court 14.
My concern is for public safety. He's already killed someone on the road with the DWI, allegedly, and now he's driving at near about 100 miles an hour, weaving in and out of traffic, causing others to brake around him.
The prosecutor jumps in and makes it crystal clear. This isn't just a technical violation, this man is a danger. Already accused of killing someone, and now caught speeding nearly 100 miles per hour. The judge listens closely, and you can feel her concern. It's one of those moments where the courtroom shifts from discussion to reality check. How much risk is the system willing to take?
And you want me to set you a bond? Really? I would like hair.
I can get.
It's not going to happen though, man. Not as my wildest dreams, as much hair as I want. I'm never going to get it back. Perhaps I can get plugs, I guess, right?
Judge, if I may, Judge. Judge, so this is a fugitive case. The basis of the fugitive case is for him to answer in the demanding jurisdiction. He had no notice that this case was open. It sounds like the comparison here to Harris County would be a 2B warrant. Nobody notified him of a court date, a court setting. The actual charge is violation of a court order. So I'm assuming.
Then comes the defense attorney. He pivots hard, arguing that this is a fugitive case and that his client never received notice of the Mississippi charges. His point, the defendant didn't ignore court. He didn't know about it. But this raises a major contradiction. How can someone with such serious accusations not know what's happening in their own case? Is this a genuine misunderstanding or a convenient excuse?
They want him to present
I don't
himself.
know that. How do you know that?
There has been no presentation made besides him having a fugitive case. If
How
that's the
long has this case been open, Amy?
Judge, I do not have that information at this time.
And that's the problem with these cases. We don't have the information. So just on the information we have, he's got a fugitive case, violation of a court order. I would ask for him to be allowed to answer for that. Is regarding public safety, he's answering for that in court 15. He's answering for that in Mississippi. This case is just to assure that he makes it to Mississippi to present himself, to avail himself to their requirements. He hasn't had the opportunity to do so. This is the first notice he's had, from what he's telling me, that he's had to present himself, and he's got a plan in place to do so.
The attorney keeps pushing. He insists his client wants to turn himself in. He says this arrest was the first time the defendant learned of the case, and he deserves a chance to correct things. The defendant even speaks up about his newborn son, saying he doesn't want to be away from him again. It's emotional, but the judge isn't convinced. And honestly, would you be?
He hasn't messed up in your court before. I'm asking for the opportunity for him to go turn himself in. If he messes up, okay, fine. At that point, we have no answer for why he messed up. But right now, he's saying he was just made aware of this when he got arrested for this. He wants to answer for it. I'm asking for the opportunity for him to do so.
Your Honor, if I may, I have a newborn son, and I'm trying to resolve all of this, because I can't do this again. I don't need to do this.
Just did.
Yes, sir. I'm
Just
talking about being away from him. I have
love and appreciate your tenacity, but I think that you are a complete danger to our streets. We lead here in Harris County, the nation, per capita, in fatalities related to drunk driving cases. We, if you watch the news, every single day.
This is where the judge lays down her most powerful moment. She calls out the reality. Harris County leads the nation in drunk driving deaths. People die every single day because of irresponsible drivers. She speaks with frustration, even anger, and the courtroom feels heavy. When the defendant says the person who died was a friend, hoping that softens the situation, she snaps back. Does that make it better? No, it makes it worse. A brutal but honest point.
Someone dying on our roads because of someone who is making a boneheaded decision to drive like a freaking maniac. And you, not only do you have this case, but you are charged with killing another in another state while being under
he
the
was
influence.
a very, very good friend of mine, Your Honor. And
Specifics.
They
will use this.
So does that make it better?
no, sir, it makes it worse.
Right.
Judge, if I may, he is presumed innocent, Judge. He's answering for these charges. He's presumed innocent. The basis of your,
Not finding him guilty, but Ricardo, I think that he's an extreme danger to public society. He's a danger to our roads. And what we will do is I will hold you at no bond in our jail until you resolve these cases. And at that point, we will notify,
The defense pushes again. He's presumed innocent, and he's right legally. But the judge is looking at public safety, not guilt. To her, the pattern is clear. High-risk driving, alcohol involvement, and a deadly allegation. She decides she cannot give him a bond. She will hold him in jail until Mississippi comes for him.
you've already notified Mississippi that we haven't, correct?
Yes, Judge.
Okay. Hey, Rick.
Judge, where he's got no other criminal history. When was this DWI?
Last year,
Last year,
May.
he's had no criminal history since this one DWI and this reckless driving. He hasn't answered for him yet. He's willing to answer for him. He's got no other criminal history besides this. We don't know the specifics of either case. I can't argue for him in either case because I don't know the specifics. He just needs to answer for
Ricardo, he's charged with killing another on the road, and now he's driving at about 100 miles an hour. I'm not giving him a bond. You will have to wait to answer until Mississippi comes and gets you. They will take you back if they come, because I don't even know if they're going to come. If they don't come and get you at that point, within the prescribed time, Harris County will release you. But me, I don't feel comfortable giving you a bond because I don't want that kind of blood on my hands. If I give you a bond and you go out there and do something, that's on me. And I have enough trouble sleeping at night as it is. I don't want that kind of blood on my hands.
Judge, can we?
The defense tries one last time. He offers conditions. No driving affidavit, wife has transportation, proof of travel, anything. But the judge has already made her decision. She says she refuses to risk having blood on her hands. This is a rare moment of raw honesty from the bench. A judge, openly admitting that one wrong release could cost someone their life. Would you have taken the risk? Or was she right to shut it down?
Do any other kind of conditions that you would find reasonable to?
Promise you, Your Honor, my
I know
son
that
is
you're
a
going
lot
to
more
promise me
important
it's
than anything.
gumdrops and tulips and little bunnies jumping in the woods, but I don't believe you.
His wife can drive him to, we could sign a no driving affidavit if that's your concern. As long as it gets him out of jail, he will make efforts to get over there. He will sign a no driving affidavit if that's what it takes, correct?
Absolutely. Yes, sir.
And he's got a plan in place. His wife will take him over there. He works at the refineries. I don't think money's going to be an issue for him. He's a welder, supervisor, something up there, inspector. And so he's got a plan in place. Holding him in jail for 14 days to wait for Mississippi is already punishing him for something that he hasn't been convicted of. He's got, we could find other alternatives to allow him to go over there. He could show you a bus ticket. He could,
I'm not giving him a bond card. I'm sorry. You're going to have to wait until Mississippi comes and gets you. And at that point, you can answer the charges, but I'm not letting you out. Sorry, just too much blood.
The final minutes make it clear there will be no release. The judge won't issue a bond, won't accept alternative conditions, nothing. Mississippi will come get him if they want him. If not, the county will eventually release him. But from her courtroom, he's not going anywhere. It's the firmest decision she could have made. And it closes the case with a heavy but decisive ending. In this hearing, the defendant appeared with two major issues: a new reckless driving charge in Texas and an outstanding DWI causing death case from Mississippi. The judge reviewed the allegations, including high-speed dangerous driving, and weighed them against public safety concerns. Despite arguments from the defense regarding lack of notice and willingness to turn himself in, the judge ruled that the defendant posed too great a risk to be released on bond. He will remain in custody until Mississippi either retrieves him or fails to do so within the legal timeframe. The decision reflects the court's heightened caution surrounding intoxication-related cases and fatality-linked charges. If you found this courtroom breakdown intense and informative, don't forget to hit like, subscribe, and turn on notifications so you never miss another dramatic moment from inside the courtroom.